So that was just to get us in the mood to talk about settlements. Obviously that was tongue-in-cheek, but you know, some of what you saw there, procedural-wise, how parties may react to trying to resolve their cases, probably has a little grain of truth in it. I found a quote that was, when two or more individuals or entities are in a protracted dispute, it is preferable that such disputants actively and voluntarily take part in solution-seeking resolution, rather than allowing their dispute to remain unresolved, result in costly litigation, continued conflict, and an elevated risk of violence. They could be talking about what you guys all do every day. It's so true in family law. So I need you to really believe in the value of settlement and what you're doing for the court. You're not, and actually believe in the value of settlement whether you're advocating for a client in a settlement conference or you're acting as a settlement officer. I was recently told that effective communication in this teaching mode, I should prepare as if I had little 90-second sound bites, as if there was going to be a fire drill out there and I needed to give you information very quickly. I don't know how to do that, so I didn't. So you're really too big of a group as well for us to do any meaningful small group discussion or interactive dialogue. So I'm just going to talk. If you do have questions, please feel free to interrupt. I may ask questions of you as well. I know you hate sitting there and me standing up here talking to you, but that's what judges do, whether we're retired or not. We talk. So the other thing someone told me is that when you all leave a presentation, if you walk away with one or two solid good ideas that you can put in practice, even if it's been an all-day presentation or an hour-and-a-half presentation, that was successful. So I hope you walk away with one or two good ideas. Take my tips and tactics for what they are, suggestions, modify them, develop your own style, and as I also recently heard, be yourself, everyone else is taken. I know some of you already have a mediation practice or have helped the courts in settlement conferences already successfully. So I hope you will offer some of your successes and suggestions for us today. 3 points before we get into the meat. You need to prepare. You need to listen to the parties to demonstrate your familiarity with the family, the issues, and the attitude, and have an attitude of how can I help you? Get the parties talking together, if you can, or separately, to see where there are areas of agreement and disagreement, and then try to close that deal. So you all know I've been doing this for a really long time. Most of you have appeared in front of me, and I've probably coerced settlements out of most of you. Okay, but at that point I was wearing the black robe, and that adds a little extra layer of, I'm going to say coercion is probably not the right word, but of authority. Because they know that that person is then going to make rulings, and you all know that as well. When you're doing the settlement conferences for the judges, you don't have that authority, so you have to build in that authority with the parties. I wasn't really sure. I know that I did what I did, but I wasn't really sure consciously or unconsciously what I was doing. So recently I've looked through books, documents, articles, and taken a ton of classes. There's so much material out there on mediation or settlement techniques that it makes my job more interesting today, but very difficult, because you can't teach mediation in an hour and a half, and that's not the purpose of this. The purpose is just to highlight some things to help you. And the other thing the other area that I've looked at recently is a mediation advocate. And that's when you are preparing your own client to go through a settlement process. And that when you buy into the idea that settlement is appropriate for your client, you can help teach your client how to go through that process. Whether you're going to be having lawyers when the judges call on you, 2 lawyers, 1 lawyer, or no lawyers, I can't tell you. But the techniques all work the same. So the difference is when you're talking to your clients, you are evaluating a case. You are directing things. When you're a settlement officer, you're being more facilitative. You're trying to work them together to a meeting point. We all know that family law is different than other areas of law, more complex, multidimensional, which I think makes resolution a moving target. The situation you come into the courthouse is one where the litigants are already in an adversarial posture, or rather, sometimes they think they should be. They're unsure of what decision is in their own best interest or their children's best interest, while considering costs both emotional and financial. Maybe they've anchored themselves to a position that they do not know how to get out of now. I have to keep, for example, I have to keep the house. I have to stay in the house. The kids have already been here their whole lives. We all can't move. On the other end, I really know I can't afford it. But they've anchored themselves into that position. And those are real life issues that you're going to have to deal with and try to finesse with both sides around that to come up with what the interest really is versus the anchored position, which we'll talk about shortly. So the other one is for support. I've given him or her the best years of my life, and now he or she should now take care of me for the rest of mine. That's another anchored position. That it's a position, there's an interest in there that you need to suss out. And so for all of you dealing with that, and for us judges, that's powerful and great responsibility to those who help them. And frankly, even though judges are very busy, they do not fail to recognize the power and that they have with respect to the parties. You're going to help the parties figure out how to stay out of the courtroom and in control of their outcomes. Here, you're not an advocate, and it frankly doesn't matter what you think is fair or right as a neutral. What matters is how you can help the parties to figure out, in their own mind, what is fair and right for them. We may use the terms mediation and settlement conference interchangeably, but there's a difference. Most mediation is voluntary, where they've signed into the process. It's earlier in the litigation. In contrast, what we do here is closer to the end of the case, before trial. Disclosures have been done, discovery and trial preparation has been done, and especially if the settlement conference is done by a judge, the attorneys and parties are looking to have the presider convince the other side to settle. That's not what your job is. Your job is to assist the court in getting the parties to evaluate their own strengths and weaknesses and positions and attempt to negotiate a settlement, but you don't have the ability to make a decision, so you lack that black robe. Your job is not to convince the other side to settle, but since you do have extensive knowledge of the law in this area and extensive knowledge of the judges that you appear in front of, and even though you can't give legal advice or even appear to do so, you can guide the discussion in light of your knowledge. However, since you do not have a stake in the outcome other than feeling good about getting it done, you are free to help them negotiate and perhaps suggest some outcomes for them, some likely scenarios. If you do this, then this. If you do this, the judge is likely to do this, not everybody, but you can make those suggestions once you gather all the information. It was very interesting going from being on the bench where we didn't have any ex-parte communications. I never talked to one lawyer by themselves. I never talked to parties by themselves. In fact, I only ever talked to the parties while we were in court and on the record. I went out to Riverside over the last 4 years and sat about half time hearing their civil settlement conference calendar. And all of a sudden, I was able to talk to both lawyers. Then I would talk to one side. Then I could talk to the other side. I could have their clients come in and talk to them. It was a wonderful, freeing position to be in. And you will have that opportunity to do that. Because you're not the decider, you can have both joint sessions and private sessions like we heard on the video. And the one thing, okay, so that, where am I? Okay, as I said, it was very free, but the tactics, the dynamics of a settlement conference are the same, issue by issue and position by position. Most of what I'm telling you I didn't invent, it's not original, but it's a synthesizing of what is out there and a restatement thereof. As I said, I hope you leave with one or two ideas you can use to help the court and the litigants. You're the court surrogates in this process, but remember, unlike private mediation governed by the Evidence Code, you're governed under the Court Rules 3.1380, and there is minimal confidentiality as to what's said. Obviously, settlement offers and those kinds of negotiations are still confidential, but what's said in those joint sessions may or may not be. When you do talk privately with each side, if you do, you can retain those confidences. And I would advise you to make sure before you say, well, I was just in with the petitioner and she or he said X, that you make sure it's okay with the other side, that you do say those things. I've been doing these really interesting phone mediations, which is a whole different dynamic. So I don't have the opportunity to see the parties, and a lot of what we get is by looking at facial expressions, hand gestures, how they react. But I've been doing these mediations where I'm on the phone and the people are all over the country and I'm talking together with them, and then I put each in private caucus. And I really, really, really had to learn to listen. To listen to what's said, what's not said, and the tenor, the tone of voice about what is said. So those things, it's really been an eye-opening experience for me, and actually it's been particularly helpful. Okay, so your role as experienced attorneys in this complicated area, your need is great. You will consciously or unconsciously evaluate the case in light of how a judicial officer might rule, but you should not necessarily express this to the parties. This evaluative style, the one is probably not best for the parties in front of you. You have to be very, very careful not to give legal advice. You're a broker of proposals and counter proposals. That's not to say, as I said before, you can't make suggestions. You must be patient, pleasant, considerate, no matter how unreasonable you may think one side is. And you must not be discouraged when the prospects of settlement do not appear bright, but always optimistic, patient, and operate with reasonable persistence. You all know me, I hardly let you go, right? I would keep working until I could get some resolution, even if it's only a little bit, to get something done. Anything that you can do to shorten the trial, to minimize the issues, is help to the court, even if the whole case isn't done. I don't know how much time you're going to have. I don't know if you're going to have an hour. I don't know if you're going to have 2 hours. I don't know if you're willing to give a whole day to the case. I'm not sure how this program is going to evolve. I know there's a few people that have already done some settlement conferences. Dory, I think you've done a few, and I think Susan Kowalski, I saw you back there. You've done some, Ms. Lawler, Kathy, have you done some as well? So, you know, and you may or may not have a private room. You may have the hallway. You may have to separate the parties. You may not have a place to meet all together. So even though it may be informal, you have to give it an air of formality so that the parties understand the importance of what they're doing. Settlement conferences are not time for socializing, bull sessions, war stories, as your time and the time of the participants are valuable financially and emotionally. Couples struggle with agreeing on matters, but most eventually recognize the wisdom of compromising, and they do so with your help. They look to you for guidance and leadership. Even though the court has forced them into this settlement process, it's your job to help them by finding and removing barriers. How do you do this? Talking together and privately, helping them understand reaching an agreement, even on the small issues, changing their positions into their interests, changing buts to ands, and negatives into constructive statements. And lo and behold, you will have them become, for you, reluctant collaborators. They will buy in to this process, and then it will be self-fulfilling. I probably knew these, but I went to a class and I heard about the advantages of settlement and in resolution. Put in like a Sesame Street, the letter of today is C. And C doesn't stand for cookie, as Cookie Monster would say. C stands for the parties will have control over their outcome, some confidentiality, their cost will be reduced. It allows them to become creative in their solutions, to do things the court could not do. And I know I've made some suggestions over the time of how to resolve cases that I couldn't rule that way if I had to rule, but the parties could. We could do a spousal support buyout. We could do other things that if you came before a judge and tried it, the judge could not make that ruling. But as long as it's not against public policy, parties are pretty much free to negotiate anything they want to. They have a conclusion and a closure and knowing the outcome and a certainty of the outcome. So remember, we can't change what has already happened, what each has done or said, but we know we have a chance to give them the power to make choices or to litigate, which is burdensome, costly in time, money, and emotions, and then ask them to consider at the end of the day, what have they really accomplished by all of that to get to the same place, except by spending a whole lot of money, which is good if you're their lawyer. That's all good. But it's emotionally draining, and so here we are. So we also talk about obstacles and psychological, strategic, structural, cultural, and interpersonal obstacles. So if you do this regularly, and you should each have a plan for comments you make to the parties in joint, and I'm going to say jointly, whether it's two self-represented parties or parties with lawyers, about your role, their participation, and that of their lawyers. Obviously, the courthouse is a problem with space, but I'm hoping you will have arrangements made for this so the parties feel that this is a formalized, important process, even though they may not have a lot of time to consider, to reconsider, and make decisions of letting go of emotions and family ties. You need to put them in a position that they're ready to make those decisions. So, interesting paradigm. In a judge-conducted settlement conference, both sides think the judge, the great evaluator, is against them. In a neutral setting, both sides think the settlement officer is on their side. Both sides are wrong. So, when I said you should have an introduction, let me just take a moment to give you a sample of what the things are that you might say in a joint session. Good morning. My name is... The court has asked me to help you try to resolve some or all of the issues before the court. We will meet together first so you can help me understand some of the dynamics at play as well as your positions. Please know that even though I'm a lawyer and I do have some expertise in this complicated area of family law, I am not your lawyer and I cannot give you legal advice. My job is to help facilitate communication, to define issues and positions, to relay them to the other side, and to work toward resolution. While I cannot give advice nor say what is fair in your case or what is right, I can, if asked, within my experience, tell you what the courts are likely to do, what they can do, and what they can't do. but not your chances of success. I may suggest some creative ideas, seek concessions, but ultimately the decisions are yours in consultation with your attorney or advisors, if you have them. I will try to act as a catalyst between the opposing interests, attempting to bring you together, helping you to define the issues, eliminate obstacles to communication, hopefully while moderating and guiding the process to avoid confrontations and ill will. So that's just a sample of what might be said at the beginning to set the tone. It's a tall order, especially for you as litigators, because you're so used to being advocates and adversaries and taking one side and seeing it all from your client's perspective. You need to take that hat off and put on that neutral mediator, settlement officer hat to do this, and not slip into the role of an advocate unwittingly causing divisiveness and disagreements. Remember, there's a state bar rule out there that says a lawyer who serves as a third-party neutral shall inform unrepresented parties that the lawyer is not representing them. When the lawyer knows or reasonably should know that the party doesn't understand that's the lawyer's role in the matter, the lawyer shall explain the difference between the role of a neutral and one who represents clients. I have a feeling you'll be talking to a lot of unrepresented parties, and they're going to look to you. They're going to look how you might react to something the other side says. So, you know that game face? Game day face. While the physical setting might not be ideal, it does need to be comfortable and equal so that no party feels threatened. Give your intro with all present. Don't show more than a mild familiarity with the attorneys if you know them, at least in the presence of the clients, especially if one is unrepresented. As judges, we always had to watch that too, because we know all of you. You come in the courtroom and we talk, say hi, or we chat with the clerk or chat with the reporter, and an unrepresented person doesn't feel comfortable with that. They don't feel that there's an appearance of impartiality. So you just need to watch that. All right, so the next phase is getting the statement of issues by the parties and gathering information. So you go here, and hopefully there'll be trial briefs, or you've been able to see income and expense declarations, so you kind of had an idea of what the issues are. And so, information gathering. After you've reviewed the file, it would be helpful to hear from the parties, together if you wish, if you feel comfortable with that, what their issues are, and help them to define those issues, prioritize them, before you can ascertain their positions and concerns. Joint sessions can help you do that. And then, unlike the judge in the case, you have the ability to meet privately to allow each side to explain and enlarge upon their positions, goals, and share private concerns, which you will keep private, even though what's said in joint session is not. When one side asks you not to tell the other side something, maybe health concerns, jobs concerns, new relationships, or even evidentiary issues, you must respect that. But there's not the same statutory shroud of secrecy for settlement conference as there is for private mediations. Questions that you want to start asking, and it's kind of important. I used to have people come in, what can I do to help you today? An open-ended question, not one that can be answered yes or no. This isn't cross-examination where you're going to, you want just to pin them down to one answer, yes or no. It's more open-ended questions. For example, I want to understand this from your perspective. Can you explain it again and help me understand why you want the house or this other asset or more time with the kids? Not the position. The position is I want, I want, I want. The interest that they have is going below that line and seeing why and what we can do to help facilitate that interest in light of what the other party wants. You're like a journalist writing a story. You want to know who, what, when, where, why, and how without seeming to cross-examine. You might ask, what do you think I can say to the other party to help them understand your position and move toward it? If you could create the fairest resolution to both sides, objectively, satisfying both respective needs and interests, what would it look like? This forces a party to get out of themselves and consider the why to their demands. What do they hope to accomplish? You know, I would have people ask me all the time, what do I do? You know, and I can't give legal advice, but what do I do? They didn't bring the child back on time, or they didn't, you know, they're always 5 days late with their support, or they didn't do this. And my first question is, okay, that's fine, but let's say the court says, okay, you're right, they didn't do that. What do you help to accomplish by that? So you need to really help them think about not only what they want, why they want it, and where they see themselves getting to. Where are you strong? Where's your case weak? Brainstorming multiple options and get permission to what you can talk about with the other side. You want to ask probing questions that do not reveal how you might feel about what they have to say, but maybe guiding them in a different direction. How would you feel if this particular thing happened, or that value were given to an asset? And get them thinking about, you know, sometimes, well, the house is worth $800,000, right? Okay, and the other side says it's worth $780,000. What does that $20,000 mean to you? And what can we do to get around it? We're not going to necessarily split the difference, although that's a really good option out there. But we're not necessarily going to do that because that may not be the right thing to do. There's a book out there called Never Split the Difference. I don't know if any of you have read it. It's by a former FBI hostage negotiator. It's fascinating. And it's called Never Split the Difference. That's my one recommendation for a book to you. It is fascinating. Take copious notes so that you can remember what's said and where you're going. But throw away those notes when you're done. First of all, you'll probably never see them again. And second, if there's some disagreements, for example, about you get something in writing and you've written up a settlement agreement, you don't want anyone later subpoenaing your notes. Okay? Just saying. I know that's really hard because we all like to save everything. We don't throw stuff away, right? You take a note, you've got it because, you know, it's got a date and time on it, and it may be your past recollection recorded, or it may refresh your recollection sometime. Don't keep them. Okay, I will tell you, even JAMS advises other mediators not to keep their notes, just for that purpose, because it really doesn't matter. Once an agreement is done and signed, that's your agreement. Can't be called as a witness. You do so many, you don't have a memory of it. So just some advice. But if there is an agreement as to anything, even a little thing, that's what STIP forms are for. That's what God made yellow pads for. And even though it's not a formal court form, Judge Meltzer, when he was here, did a pro forma settlement STIP, which is a little more, it's off of LA's STIP forms. You might just want to use that as a guide. It's not a court form. It's nothing formal, but it will help you think of what issues there are, other things that the parties may not understand about legal custody, and other things, and the things that are in fact required to be in a judgment that may not be on the STIP form, because don't they always get upset when you do a stipulation and it's got point A, B, C, and D and subsets, and then the judgment comes and it's 20 pages. And it's, well, I never agreed to that. I never agreed to that. Those are those things that are required to be in a family law judgment that the parties may or may not understand. So that'll kind of help you remember that. So it's not a court form. I didn't invent it. It's off of the LA forms, but it will help remind you of those things that the parties need to talk about. So when you're listening, consider restating the factual content back to them to make sure you understand without judgment. You might find that in doing that, there's an agreement. They're both saying the same thing. Maybe it's in different words, and by restating it back to them, you can find that there is in fact an agreement. So let me see if I understand. So you are saying, and then those key words. Reflect, stating the emotional content of the speaker's message back to them. This also does not involve agreement or disagreement, but you're acknowledging that their feelings exist and that they are part of the dispute. Especially with family law litigants, that's really important. They need to be heard. We as judges don't always, in the courtrooms, don't always get that opportunity. And I know how frustrating that is, because we don't have time to hear every single case, to let the parties have that opportunity just to let it fall out of their mouths. But you hopefully will have that time to let them say things and then bring them back to where you really need them to be. You seem or you feel, and that will help in that matter. You can reframe an issue. This involves recasting the statement in a more neutral term, giving the speaker a chance to look at the problem from a different perspective. For example, I know you can't agree under these circumstances, but under what circumstances could you agree? Right? You know, I keep going back to the house. You know, one side says, I gotta sell the house, I gotta sell the house. The other side says, I want to stay in the house. I know you can't agree under the circumstances that they're proposing, but are there some circumstances that you could agree to allow them to stay in the house? And explore that, because there may be some movement there. May not, but there may be. Again, redirecting the thrust of a negative assertion from the person's attacks to the problem or issues in the dispute. Is there another explanation about what happened or a specific issue you would like to work on? You know, you think you saw your spouse doing X. Do you think there's another explanation to it? Can you think in a different direction? Or are you always looking through those negative glasses? This turns positions into interests, negative statements into constructive actions, and enemies, as I said before, into reluctant collaborators. Summarize by reviewing what you've heard. Identify as many interests as possible from each side to better understand what is important and getting positive options. For every interest, there ought to be various ways that the parties can meet those. Ask them to suggest some of those. Both parents want kids to be happy, presumably, and well-adjusted. That's a shared interest. How do we get there? So we're going to explore those differing interests. Explore trades that are high in value to one party and how low cost to the other, and you can work on those trades. Conflicting interests, if you have conflicting interests, use objective criteria to decide and help them decide on a fair solution. Maybe one party who wants the house is willing to trade off something of high value to the other party. Don't you suggest. You ask them for suggestions. Because you don't want to put ideas in their head, because once you do, they can get anchored to that, thinking that's what the evaluator or the temporary judge thinks. They know. And so we're going to do that. So you want to really be careful about making suggestions too early. I know you guys have been in my court too, where you go, well, Judge, what do you think the attorney fee order should be? Right? Well, I'm not going to tell you, right? But I'm going to make you tell me. And I've made you very many times. I said, I'm going to write what I think the right answer is, and I'm going to just put it on a piece of paper here. And then you guys are going to give me, on a separate piece of paper, not tell the other side yet, what the most you think is an appropriate attorney fee award that your client might be willing to pay. And the other side, what's the least amount you think is the appropriate attorney fee award? And then we're going to all open those together. Then you're not making the suggestion, but you're getting them to think. One as the other side, as well as to get to the middle. So you could use that as well. The other thing I think that's going to come up is pets and household pets. You know, there's a new code section out there dealing with giving the judge the authority. Oh yeah. It doesn't say shall. It says may. Upon being asked, award ownership, not custody, and it's final ownership, so it's not modifiable, of a household pet, however you might think to define that, to one side or the other, not considering the pet's best interest or how you're going to pay for it, but whether or not the care and health of the pet. And they don't define what a pet is. Can also now, I don't know if any of you have dealt with it, I just found it fascinating that that's even out there now. I know AAML was against it, and the Humane Society was for it. But there's also a procedure for pendente lite care of the pet. But it doesn't say who's going to pay for it or provide support or talk about support for that animal, who's going to buy food, if you can factor in, if you request I'm going to have the dog and the dog is a 100-pound dog and eats 100 pounds of dog food a day, do you factor that into your expense, your income and expense statement, so the other side might have to, the court might have to consider that in awarding support. I don't have answers to that, but those are ripe for settlement. Absolutely ripe discussions for settlement, especially as to what is a household pet. What if it was a gift to a child for the child's birthday? What if it was a gift to the other spouse? What if it's a service dog? Or a service chicken or turkey or snake? Or a house, I don't know. We don't know what a household pet is. It's not really defined. So those things are all ripe for settlement and resolution. Okay, so the next thing beside prepare and ask those probing questions is listen. Listen, listen, listen. Don't be thinking what the next words are that you're going to say, but listen to what's said and how it's said, and also what is not said. I'm going to give you a few examples. Watch for these phrases signaling an unstated admission that there's more to tell. Well, that's about it. That's pretty much our position. There's not much more to tell. Well, what are they not saying? So you should ask, please tell me the rest. What else do I need to know? Watch for phrases signaling they can't reveal more information to you. I can't say, I can't think of anything, I'm not able to say, I couldn't really tell you that. Is it that they don't know or they don't want to tell? So you might want to ask, what can you share with me? Watch for claims that have no proof for the assertion. You never had that happen in family law. Okay, no proof, but that's the way it was. You might hear, there's absolutely not one piece of proof. You might hear, show me the evidence. There's no proof. No proof exists one way or the other. And what evidence do you have? Instead of answering the question, what evidence I have. And that's where you might get them to exchange and further discuss their duties of fiduciary duties and their duties of disclosure with the other side, so that they don't run into something 5 years later where they didn't disclose an asset or the value or what was done, and the whole case gets undone.
Oh, wow.
And yeah, and it happens. Okay. Watch for projection phrases, a defense mechanism where a person voices their own fears while attributing them to somebody else. A person would have to be crazy to expect that. Sounds like that person is a real fool. You'd have to be a jerk to make demands like that. So, the party might really be referring to themselves and is aware that he or she is appearing in an unfavorable light and is concerned about it. You might say, well, we all make mistakes. What really happened here? Experience is a wonderful thing. It enables you to recognize a mistake and not make it again. You know, your clients, when you're in practice, and people that I see, they talk bad about the other parent all the time. And I think I've said over and over again that when you talk about the other person or bullying or any of those things, it reflects less about the person you're talking about and more about yourself. And that's what that was talking about. Okay, so gathering information, and then you're going to have to define your approach. These parties are anxious, nervous, highly distrustful, would probably be rather anywhere but here, but mostly they want to be done. Okay? And you can do this by being facilitated. And by setting the tone to a conducive to discussion, sharing ideas, not taking one side or the other, but helping them to find practical solutions. As I said before, a position taken by a party is what they want or demand, and interest is why they have taken that position. And that's what you have to delve into. And once you've gotten to that, you can help facilitate the conversation to them and get them going in a settlement direction. I settled a case, a civil case. It had to do with a business, and it was a bar, a couple bars. And it was a very specified kind of bar that had all kinds of decorations and things that were important to that genre of the bar. And one person, or they sort of kicked one person out of the partnership. Out of management, out of the partnership, and they were trying to get some money back. And there were some financial issues and tax issues. It took us about 3 times of me getting them back in, and it all almost blew up over a door handle. Because one party wanted the door handle that matched the other one that they had that was of this genre. Now, we all might not understand that. It might be like the pet, just go buy another one. But you need to find out and delve into what those underlying interests are that might make the whole thing blow up. Eventually we got it done, and I don't remember how. But it was over a weekend, and I did have to give them a non-enforceable be nice to each other order and don't talk about anything over the weekend. Because they were all within the same group of people. But you don't know what that thing that is very, very important to the other side is. That could be the linchpin, and it could be as simple as a door handle. It could be a photograph. It could be anything. And you need to find out what that is. A facilitator explores those interests. And if you can't get the parties beyond positions, you're unlikely to resolve the case. Focus on interest changes the way the dispute is characterized, analyzed, and processed. So then you can manage their expectations and uncover what's critical to each side in seeking a resolution. What's most important to them? The house, receiving or not paying support, timeshare. What is it that you might want to start with? Because, God, there's so many issues in family law, right? And you can't just say we're going to settle everything. You've got to pick one issue. Some judges think that you should take the smallest issue, like you keep your car and you keep your car. And I've done that when I've talked to the parties and done a settlement conference at trial, self-represented on the bench. Said, you each have a car. Can we agree that you keep one and you keep one? Oh, yes, Judge, but hers is worth a lot more than mine. Right? Okay. Do I have permission to go on Kelley Blue Book? And let's Blue Book the cars. Oh, that's a good idea. We do, and we usually find out they're probably worth about the same amount of money. But we've got them talking together. That's a very facilitative approach. I'm not evaluating the case at that point. So I like building on those small issues first. Once you get the parties into the mode of thinking about agreeing and compromising, then you can get to the harder issues. There's another judge that I talked to recently, because I did ask a few of them what their thoughts were. They said, no, I'm going to tackle the hard issue first. That huge linchpin issue first. And then everything else will fall into place. That might be the case if you have a business that needs to be valued. And until that business is valued and you agree on the value of the business, you can't get anywhere else. That may or may not be the cases that you're hearing. My guess is that you're going to be taking the cases that have smaller values and maybe not the business, but you never know. So I think it depends on the kind of case you have. It depends on your take of the parties, if they're self-represented, or if you have lawyers that are working the process along with you. As lawyers, you're really good at developing facts that support your positions. But it may bog down when it comes to, for your side, developing settlement options. I remember when I was in practice, we used to do as much as we could, and we wrote a settlement letter to the other side that says, here's what we want, here's why we want it, tell me why we can't have it. Okay, that's a very directive approach. Okay, that's not going to work for this. So this is where you've got to get the lawyers in the mode to look at options. It's a lot easier to look at an option, a menu of options on this particular piece of property, and for example, 2 or 3 of those might be really good options. Let's pick 1, 2, or 3 of one of those, as opposed to saying, this is what it's going to be, and then try to dress it up or divide it or alter it. So options are always very good. As a settlement officer, you can explore suggestions as to the available options that have and have not been previously considered. Once the parties have identified their options, they can assess the merit and begin to negotiate their acceptance. You serve to facilitate communication, test realities, and offer encouragement. And so you might ask, have you thought about this idea? What plans do you have for the future? Have them evaluate, but help them to reach the decision on their own. Watch for words. Watch your words. Use proposals instead of positions. Use resolve instead of compromise. Use and instead of but. And then shy away from some non-negotiable words if they go, this is a firm proposal. Figure out a way to take those words and reframe them into something more neutral so that you can get them considering that they might have to move off of that position. They're to reframe or translate their position into interest, dive below the waterline, help them focus on real needs versus stated positions. For example, I want my 50% custody. That was always one of my favorites. Reframe. It sounds like being available so you can meaningfully contribute to your kid's development as she moves through life is really important to you. Okay, that's reframing the issue. If your child support payments stayed the same and you had liberal timeshare, would you be willing to consider less than 50%? Find out what's really driving the boat there. Is it money? Is it spending time? What happens if one side is disrespectful, intimidating, or threatening? We never had that happen to you. I'm going to suggest that you stop, walk away, and don't engage. And let them have time to cool down. I know that when I've been on the bench and I've had mostly self-represented people, very few times lawyers, but mostly self-represented people get really, really upset. And they're like this over counsel table and talking very fast and very loud, so my bailiff has to come stand behind them. I usually will say, you know what, I'm going to get off the bench now. I'm going to give everybody a chance to cool down, and we'll come back when everybody's had a chance to calm down, and we'll start again. I think the same thing happens with settlement conferences as well. So you let the situation diffuse. You can come back to session in a calmer demeanor. We do realize that divorcing spouses probably lack the ability to be consistently respectful and totally honest with themselves and the other party. But that's part of what we deal with here. Preparation for the settlement conference, if they're represented by an attorney who have schooled them, him or herself, in mediation advocacy, as we talked about before, goes a long way toward resolution. You need to build trust by listening and observing, compliment them for being part of this process to control their own destiny, and even sometimes take those personal decisions and make them into a business decision, which takes some of the onus off of the emotion and makes it a little more unpersonal to them, and it helps. Okay, so let me see, I have one more thing. I keep going back to the home. I really want to stay in the family residence, but I know you're entitled to your share. What can I give you to make this happen? What if staying in the home creates the need for more support so that it's just not practical? Ask the party to analyze this from the other side's perspective to give them more perspective to their own. Again, frame the question, turning it back onto them. Validate them, appreciate their willingness to say X or say their position, empathize by identifying with the other's views, even if you disagree, clarify, and summarize. And again, I'd be careful about giving your own opinions. You can say what the rules are, but you can't define how they would be applied. Be careful with the evaluative approach as to probably the outcome of specific factual or legal issues or the whole case. And I would remind the parties and counsel that our area of law is one where we're full of judicial discretion, which is why you can never say what this judge or that judge will do. You can give them a range of options. These are things I've seen done. These are things you might want to consider doing. But you can never tell them this is what will be done. So when you get an agreement or partial agreement, write it down. Have the parties sign it, file it, or go into court and put it on the record. So, and to avoid settlement remorse, that's huge, because this is quick. It's quick, it's not dirty, but it's quick and dirty. It's in the hallway. They don't have tons of time to consider and reconsider, and you don't want your clients walking out when you've settled something and have them go, oh, I shouldn't have done that. What in the world did I do? So you need to work to avoid that later settlement remorse. Congratulate them on what they've accomplished, even if it's a little bit, that the judge will appreciate whatever small steps they've taken toward resolving their issues. So, I just have a few, I want to tell you a few things. Okay, so, what I learned from some of our more experienced judicial officers, and when I read this list, you will probably say everybody does it different, which they do. I think I started this with be yourself because everybody else is taken. And that's how you have to be yourself and be genuine in the process. So, open an MSC with how do you suggest we proceed, and it procurs, have them write it down, review it, and be surprised on the things that they might agree on. If you give up on this issue, then I will on this issue, and compromise. Lecture about the value of settlement as they know themselves and each other and their life better than you do or the judge does, and they can have a say in a workable solution. Have a fresh start today, and never just split the difference. Take the hardest issue first, otherwise you might get mired down in minutiae. Don't let the parties get locked into their positions early. Look for patterns. And I love this one. Look for patterns. You know, they say history is the best predictor of the future. People vote with their feet. And with what they have actually done with money and timeshare, not what I could have done, should have done, wanted to do, or will do. Make sure you spend enough time with both sides. Find out what they agree to first, and this may take some time, even if it's a small issue, like we talked about with the car. You'll find that building up to larger issues, with ProPERS especially, really works. If you can, stipulate to facts, and over which there's no dispute. This will really help the judge, and then agree on what you disagree on, and set forth those issues and contentions. Again, even though you haven't resolved the whole case, you have really done a service to the court by defining those issues and probably shortening the time for trial. Bottom line, you should be a calm guiding force who's trustworthy, humble, patient, and kind. God, that sounds like scouting. Principled, ethical, non-judgmental, patient, empathetical, logical, and rational. You should have people skills, team building skills, listening skills, and verbal skills. You are the leader, but you're not in charge of the process. You're in charge of the process, but not the ultimate decision. And you want to make sure that whatever the parties do agree on will be approved by the court and enforceable. While you can't tell the parties if what they did was fair, you can make sure that their decisions are informed and not against public policy. You can explain the difficulties of certain resolutions and make sure they understand. Do they think it's fair? It's not your job to change their minds. It's your job to make sure they're not under some misunderstanding of law and facts, and that their own rationale for decisions is sound. So it's a little bit of, at the end, evaluative. Make sure neither party feels too exhausted, pressured, or overloaded with information to make a good decision. It is okay to come back another day. And finally, you will leverage your experience to offer opinions that will help resolve, will you leverage your experience to offer opinions that will help resolve the problem? The answer should be no, unless specifically asked, and I would do that only if there's two lawyers and you are meeting with them privately. So, that's a lot of information. And I thank you. I'm open to questions, if any. Yes?
Yes, if you're working with a couple at ProPER and you believe that another session would be helpful to get the case resolved, can you go in and ask the
Absolutely. Court? Yes. I mean, if you're willing to give your time to help these people resolve their case, bless you. And I am sure the court will make whatever arrangements are necessary to get that done. Absolutely. Because you're here to help the court, and that's why this program is being more formalized. So I think they're going to try to set up a settlement conference day, 1 or 2 days a month, where maybe you will have a courtroom. Maybe you will have a chambers to talk into, and a more private, formal place to get this done instead of the hallways or the attorney rooms. Yes. Any other questions? I have also, along with the sheet of settlement issues, a sheet of good questions a good settlement judge asks, and mistakes that a settlement judge might make. Not exhaustive. There are tons. And as I said, there are courses upon courses and weeks upon weeks of classes in all of this. So in an hour and a half or hour and 15 minutes, we can't do that. But I hope I helped give you some ideas, and I say thank you.